Hello, this is Law and Terrorism, the podcast series. I'm your professor, Glenn Torres-Spelliscy. Thanks for joining me.
Thanks for joining me for this week's podcast. The topic this week relates to U.S. detention practices in the war on terror, and because of the nature of this week's topic, much like I did with the story of Afghanistan invasion a couple of lectures ago, I'm going to vary from the typical 5 key questions approach and provide a narrative tale. If you have any questions, please don't hesitate to contact me, and I'll see you next week for another edition of 5 Key Questions. Now, the war on terror no doubt raises some incredibly difficult yet significant policy issues. As a matter of policy, how we treat people in our custody, particularly when from a moral perspective, they may not deserve to be treated gently given their own actions. How we treat these people is a definitional issue for us as a country. How do we overcome the desire for revenge, the desire to justify anything we do to these individuals under the mantle of national security and self-defense? The lecture and readings this week will range across a number of topics. We will discuss international domestic standards related to torture, as well as focus on a series of memos drafted in 2002 by the Bush administration's Office of Legal Counsel, particularly the memos drafted by John Yoo and Jay Bybee. These memos offer guidance to interrogators on what type of practices were allowed and which were prohibited under both domestic and international law. The guidance offered by these memos was in place for about 3 years. Then, in 2004, they were leaked and made public. Shortly afterwards, the Bush administration forcefully and publicly rejected the memo's conclusions. However, as we will discuss in the lecture, although they rejected the memos themselves and some of the memo's broad statements about executive power, they did not reject the enhanced interrogation techniques that were being employed, primarily by the CIA at various black sites throughout the world. Indeed, for the remainder of his administration, President Bush took great pains to ensure that new legislation, like the Detainee Treatment Act or the Military Commissions Act, did not interfere with the CIA's inability to use enhanced interrogation techniques. It wasn't until President Obama signed an executive order that compelled all U.S. government agencies to adhere to the Geneva Conventions concerning treatment of detainees that the enhanced interrogation techniques were stopped.
I have put an end to the interrogation techniques described in those OLC memos, and I want to be very clear and very blunt. I've done so for a simple reason, because I believe that our nation is stronger and more secure when we deploy the full measure of both our power and the power of our values, including the rule of law.
There's been no public indication that President Trump has resumed the techniques, but he did say on the campaign trail that he was not against waterboarding and other such techniques. It is not clear yet how President Biden will address the issue of treatment of detainees at U.S. facilities like Guantanamo Bay. In February 2021, the Biden administration announced plans to study how to effectively close the base, and Defense Secretary Lloyd Austin said during his confirmation that the Biden administration, quote, does not intend to bring new detainees to the facility and will seek to close it. What that means in terms of how detainees are treated remains to be seen, but it is likely that we'll see a return to Obama-era policies. In addition to questions of treatment, there's been a lot of discussion about how we dispose of these individuals, whether they should be subject to trials in federal courts or to trials in military commissions. And we've even have some individuals who the government says we have to continue to detain despite the fact that we cannot put them on trial because the evidence against them is tainted. Nowhere in the U.S. Constitution does it say that the U.S. government can detain any individual, citizen or not, without charge and a speedy trial. It is possible under international law to detain a prisoner of war until the end of the conflict, but the United States has taken the firm position that these individuals are not POWs under the Geneva Conventions, and indeed it has not treated them in accordance with other POW standards set out by those conventions. There are currently more than 20 individuals held in indefinite law of war detention who are not recommended for transfer to another country. How do we deal with them? Do we need to update the legal frameworks to permit some sort of indefinite detention? As we approach this week's topic, I want to reiterate what I said at the beginning. This is a definitional issue for our country. It presents a fundamental question that we must ask ourselves, and it's not whether we're good people or bad people. That's far too simplistic a classification. I think the key question that we have to pose is whether we're a nation governed at all times and in all circumstances by law, or whether we are a nation governed by laws that bend to the necessity of a particular political moment. Both approaches have strengths and weaknesses. If we are a nation governed by law, that means first and foremost no individual is above the law. This is a maxim we always hear, but conversely it also means that no individual is below the law. All individuals, no matter what their circumstances, are entitled to the same levels of protection.
I am reminded of President Theodore Roosevelt's third State of the Union speech in 1903, where he says, quote, "Whenever either corporation, labor union, or individual disregards the law, or acts in a spirit of arbitrary and tyrannous interference with the rights of others, whether corporations or individuals, then where the federal government has jurisdiction, it will see to it that the misconduct is stopped, paying not the slightest heed to the position or power of the corporation, the union, or the individual, but only to one vital fact. That is the question, whether or not the conduct of the individual or aggregate of individuals is in accordance with the law of the land. Every man must be guaranteed his liberty and his right to do as he likes with his property or his labor, so long as he does not infringe the rights of others. No man is above the law, and no man is below it. Nor do we ask any man's permission when we require him to obey it. Obedience to the law is demanded as a right, not asked as a favor."
This approach emphasizes the value of the individual's life and liberty, and represents some of the core values that we see reflected in our founding documents like the U.S. Constitution and Bill of Rights. Under this approach, the liberty of the individual is maximized vis-a-vis the safety of society, and as a result, there is a potentially higher risk that society will suffer harm through some sort of attack, or that a guilty individual will get away. On the other hand, if we believe our laws should be governed by the necessity of a political moment, that they should be somewhat malleable in certain circumstances, that they should bend in order to allow us to achieve certain political goals, we're adopting an approach that emphasizes the importance of the well-being of society as a whole as compared to the individual. Under this rubric of thought, it is acceptable to mistreat an individual if doing so benefits the society. We are willing to use any means necessary to protect the larger community, and likely have a better chance of doing so. But there are a couple of serious reservations I have with this approach. First, there's no guarantee that any individual who is mistreated will provide actionable intelligence. Indeed, most experts who looked at this matter have come to the opposite conclusion, namely that torture does not provide reliable information. Secondly, and more fundamentally, I think there's the problem of who gets to decide whether we're going to derogate from the law in a particular circumstance. Who makes the decision? Is it the president? A judge? Should Congress play a role? You see, the problem is that there is a potential for abuse that results from any ability of the government, or any individual within the government, to deviate from the law when they deem fit. I'm not sure what the right answer is. I know what I think, and I don't want to prejudice you as to what you should think. But what I will say is I've seen arguments on both sides of this debate put forward by serious thinkers and students of law and policy. From my perspective, I believe that we are a nation founded upon the rule of law, that all people are equal before the law. That is the founding maxim of this country, and we have to accept the consequences of that reality. If that means that we are not as safe in the short term, I'm willing to accept that, because I believe adhering to the founding principle makes us safer in the long term. Well, that's it for this week's podcast introduction. There's a huge amount of material to cover this week, so get to work on reading the lectures and the assigned readings, and let me know if you have any questions, and I will see you on the discussion board.